In studio right now, as if we're not going to stir up a little more controversy.
Sorry about that.
Here is Mike Daley. Daley is running for the district attorney spot in Herkimer County, and you're on the Democratic line. It was a rather tight primary in the Republican race, but you lost in that primary. You're on the Democratic line, and we had your opponent, who is the incumbent, Jeff Carpenter, on the air the other morning. And you've taken offense and have felt that you deserved an opportunity to rebut.
Well, some of his statements that I would like to deal with. One is, in dealing with the Cyber case, he flat out said to you...
So you got to give a little background on the Cyber case. Is this the Dowsville case?
This is the Dowsville case where... And we'll use his numbers because he doesn't believe that my numbers are accurate. I do.
He did say that you're making these numbers up. That when you say that Herkimer County is not safer today than it was, he said you're making the numbers up.
And he said that my numbers on the Cyber case are not accurate. But let's just use his. We have 7 victims of this defendant. Multiple offenses against each victim. This defendant was arrested in September of 2015. The grand jury proceeding was in February of 2016, 5 months later. And apparently he had not prepared these witnesses so that they could go into the grand jury and give testimony. And he made some reference to having them kicking and screaming or crying in front of the grand jury, which is absolutely ludicrous.
Should I go and grab these children and drag them onto something to that effect?
Something to that effect.
Okay.
2 things should be noted. First of all, 5 months to prepare a case for the grand jury when the statute says that if you're in jail, and he was, you have 45 days. The state legislature put in place a procedure where reluctant witnesses for grand jury can be videotaped with just the person that's asking the questions, their counselor, and the victim, so that you can proceed to the grand jury properly preserved, but proceed to the grand jury without the impact of testifying in front of people.
Testifying, okay.
That's number one. Number 2, the disposition of 9 years is appalling. For somebody who has committed this many crimes against this many children, he asked, what would I have done differently? And all you have to do is look at my last trial in Herkimer County was a guy by the name of Matthew Waldron. He molested 2 children. A total number of felonies of around 8 or 10. I don't recall exactly. You work with the children. We brought them into the courtroom. We sat them down in the witness chair. We had their counselors with them the whole time. Then we brought them back into the courtroom. And this time we put people at counsel tables so that they're familiar with where everybody sits. And a third time we bring them back and we put people in the jury box and people in the spectator section. We brought them back into that courtroom probably a half a dozen times. When they testified, they were comfortable and aware of everything that was going on. Matthew Waldron was convicted, and he was sentenced to 130 well-deserved years for what he did to these kids. And one of the kids said to me afterwards that he felt for the first time in his life, and these are young kids, these are 8 and 10-year-old kids,
yeah,
that he had the power over the monster instead of the monster having power over him. Thereafter, in speaking with his counselors, the counselors said that the greatest leap they made in their recovery was after they testified, because they realized this man could no longer control them. And when he was sentenced, they realized this man will never be a free man again. Mr. Carpenter knows this because after he was sentenced, there was an appeal. Carpenter did the appeal, and ultimately the appellate division reduced the sentence to 65 years. But this man will never be a danger. And I don't care what you say about these kind of people, they will not change their stripes. So to allow this man back into the community, you are endangering untold numbers of future victims, and your obligation is not only to the victims of the current case, but your obligation is to the victims of any future cases. And that's what I did differently. That's what I would have done differently here.
So you feel it's based on the fact that the danger that could occur if they do a shorter sentence, it's worth possibly putting the kids through a difficult trial. It's worth it to protect other children?
These children came forward on their own to the police.
Yeah.
This wasn't something that he got caught doing. What occurred here is one of the prior victims, who was now, I believe, 16 or 17 years old, observed young children.
Are you talking about the Dollarville case? Or the one that you
Dollarville
did?
case.
Okay.
Observed young children going there, and he went to the police and reported this, and then they investigated and uncovered these other victims, all of whom gave statements to the police. So they were willing to cooperate throughout the investigation. 4 of them actually showed up to testify, and why you can't be prepared for testimony after 5 months getting ready to go to the grand jury.
So he had posed the question, how would you have handled these cases differently? What you're saying is the law allows if there was some sensitivity and the victims felt uncomfortable, the law allows for you to pre-record the interview with counsel and a counselor for the child, and that can be played for the grand jury.
Yes, that's what the law allows.
But you would,
and is routinely used in these cases.
But you would basically try to create a bit of a routine by bringing them into a non-trial situation into the courtroom several times in order to make them feel.
Yes, that's routine also in these kind of cases, so that they're
Is
comfortable.
it possible that in this case these parents said no to the DA?
I'm not privy to the conversations between the parents and the district attorney, but I can tell you that they were very supportive when the cases were reported to the police. They were there to support their kids when they appeared in front of or for testimony in front of the grand jury.
Okay. And you're also upset with the what was it, 9 years, I believe you said was the
9 years is totally inappropriate. I mean, you're talking about not only did he violate 7 kids by Carpenter's account, but he did it and made these other kids watch as he did it, so they knew what to do when it was their turn to do it. And it was an appalling case, and you had eyewitnesses to these events.
Okay, I would simply say, though, that this is why I think that a debate between you and the DA would be helpful to not only us, but to the Herkimer County community and the voters, so that, you know what I'm saying?
I completely agree.
Because it would be awesome to be able to have Jeff Carpenter, respond to that statement. Instead, we get you on a Friday, we get him on a Thursday, and then you come back on another Thursday, and it's just all it would be nice to have it done in one debate setting.
I agree, and the issue on the trials, he made a big issue out of that. I went back and checked. There was a bench trial on this Desmond Washington. I had checked for jury trials, so on the issue of the trials, there was a bench trial and one jury trial with Crandall as the judge. And the point that I'm making with Crandall as the judge is when the legislature found that there were district attorneys and judges who were just not doing their jobs back in the 70s and early 80s, they put in plea restrictions. That as part of the law, if you're charged with a certain felony, you cannot plead below a certain level. That is something, and Mr. Carpenter said that he would not violate the law when he's talking about signs, but that is something that they routinely violate when they take pleas. And nobody knows about it because you have a judge that's going along with what the DA wants when they actually violate the plea restrictions that are in place.
All right. We'll reach out to Jeff Carpenter. You're asking for a debate. I will say, in fairness, be careful what you ask for. With him in studio, he made some pretty tough accusations the last time he was on the air. Talks about misconduct, talks about all these different things. He's going to say that to your face, and the two of you go head to head.
I am very comfortable and can explain all of those issues, and I was never, other than a judge who criticized me on a case at the appellate division, I have never been criticized or been held responsible for any misconduct as an attorney or as a judge.
All right. I will say one thing. In a case of, I know you get two candidates going on. We're trying to set up a debate for the congressional candidates, and it's a struggle getting it all together. But these are, I would think this would be the easiest debate to set up. We have two prosecutors who debate for a living. I would think that this would be our easiest debate to set up, but
that's what a trial is. Essentially, a trial is a debate. You're in the courtroom, and instead of voters, you have a jury. Here, the jury is the voters, and it really should take place.
We'll continue to try to set up that debate.
Just to go back on that, he did, and as Bill pointed out, made the claim that you were, again, I don't have it in front of me. You're saying you were not reprimanded for misconduct for going forward with a case where you knew that I believe the defendant, it couldn't be proven he was responsible or was not involved in the case.
And it's actually a lot more complicated than that. What essentially happened was there was a fraud under workers' compensation and a grand larceny. The defendant was indicted on grand larceny and insurance fraud. After the indictment took place, we determined that the insurance fraud did not cover workers' compensation. The judge was notified. The defendant and his attorney were all notified. We also worked directly with, at the time was Ray Meyer and Jim Seward were our senators. Mark Butler was the assembly person to specifically change the law. They changed that law. I was criticized because at the appellate division because we went forward with our case, not a trial as he indicated, but a plea. He came in and the defendant, a guy named Van Wee, wanted to plead to the insurance fraud instead of the larceny because he didn't want to be known as a thief. We allowed that with a waiver of appeal, but then when they changed the law, there was a legal mechanism that allowed him to appeal it, and that was the source of the criticism.
All right. Okay, again, back to the debate issue. You've indicated you'll do it at any time, any place, and we'll try to set that up. It would be a lot easier again than to have you come in, and then we have to have we really work to be extremely fair and give each party the opportunity to be able to defend themselves after charges have been made in this very heated campaign that's going on down there in Herkimer County. You got a little civil war going on. I think you do. I've heard people say it's not true, but there's a civil war certainly going on in the Republican Party. It does seem. Mike Daley.
Yes, and also I have the endorsement of the Independence Party, just so you know.
So you're on Democratic line and Independence line.
That's correct.
In November. Okay. Got a break here. Hold tight.